everything in each of these counts. So the government has to prove all three beyond a reasonable doubt. And if any single aspect of these counts is not proven beyond a reasonable doubt, you must acquit. And you have to consider all the evidence presented by the prosecution and determine the facts, whether they have shown as a factual matter that the communication that was intercepted at the point of the interception was in a part of a system that affects interstate commerce. And you have to find, for the hacking count, that Mr. Weasel's motive was private financial gain or commercial advantage. And they have not shown that. For the wiretap charge, the screenshot captured a local activity, an activity on the computer, and that's not part of a system that was affecting interstate commerce. There was no evidence, for the hacking charge, there was no evidence that Mr. Weasel had a purpose of commercial advantage or private financial gain because, well, let's start with the wiretapping charge. It's designed for the interception of phone calls. In the modern age, it's also been applied to electronic communications like emails. But what we have here is a screen grab. A screen grab goes beyond the scope of the statute. It is not something that is part of the electronic communication. Now, it may be that prior to the screen grab, Mr. Zuckerman was engaged in electronic communication with somebody else, going back and forth on the instant messaging. But that communication at the point of capture was between the video buffer and the monitor. It was put over to the file system. It was something entirely internal to the computer. So you have to think about what is the system at issue. I like to think that the system is large, that it is the system that would include everything all the way through to the internet. But the system that was captured was the system inside the computer. You don't have to say it stops at the network interface card and that not 18 inches inside the computer, because here it didn't go. It was not captured between the CPU and the network interface card. It was captured elsewhere and locally within the system. And as Mr. Hobbs testified, the program simply copies the bits in the computer's video memory into a file on the client's computer. Nor is it important what happened after it was captured. After it was captured, it may have been transmitted over the internet, over a system that affects interstate commerce. But that's not important to the charge because it's beyond the point of capture. The only thing, the only fact that this jury needs to look at is what was going on at the point of capture. And if you don't have the necessary elements to show that the system upon which it did the exploit, made the capture, was a system in interstate commerce, you must acquit. Now, with respect to the hacking case, we're not contesting that Mr. Weasel got onto their network. He admitted as much. He's being honest with you. He's upfront about what he did. And the reason he's upfront of it is because he believes in what he did. Maybe that's wrong. Maybe he shouldn't have done this method to expose people to public. But he was willing to do it. Think of that as perhaps some civil disobedience, that he was taking a hit in order to bring some information to the public. And perhaps if it had been charged as such, this might have been a misdemeanor. But what it is not is the felony that they have charged. And the key to that is what the motive, whether or not this was done for commercial advantage or private financial gain. The evidence shows that Mr. Weasel acted simply out of a motive to help the public. And the public was helped. He wanted to let the public know who was behind my twit face, and then the public could make its own decisions about where they should go and what they should do with their social network. Now, many of them did choose to come over to Vapor Aspera and leave My Twitface. But they did so based on the truth of what was shown to the public, based on the information that was done. That is the natural consequence of it. But that is not a commercial advantage to Mr. Weasel. He is not an owner of Vapor Aspera. There is no owner of Vapor Aspera. It is something which anyone is free to use, and he gets no money anytime someone uses it. He doesn't receive a salary. He doesn't get paid as a consultant. He has no shares to sell. There is no advantage to him personally for more users to come to Vapor Aspera. Now, the evidence also shows that he was extremely passionate about privacy. And I think it seems that that was a genuine belief. Now, Mr. Ohm would say, well, okay, he seemed to concede that, but say, well, there might be two motives. But the evidence wasn't there to show two motives. The evidence instead showed a single motive, and a single motive to help people's privacy. Now, Mr. Ohm, the government, would like to make a big deal about the invitation to the FRED conference. This invitation occurred after the exploit took place. It was not something that he had invited. It was an email that came to him out of the blue. He had no reason to expect that would come. He had never been invited to the FRED conference before. It was not something that was in his mind. And one thing that is critical when you're considering what his motive was is the motive at the time he did the exploit. His motive when he went on the system. When he went on the system, he didn't even know what was going to be there. I mean, he had some certain suspicions about Mr. Zuckerman, but he didn't know what he was going to find. He didn't know what video he would capture, what screenshots, what PowerPoint slides. The evil plot was presented to him at the time, and they took advantage of that, perhaps, because he wanted to have the public see what it was. But when he was doing it, he didn't have a financial motive. So if he got some financial benefit afterwards, that is not a fact that is useful to determining what his motive was at the time. So the government has not shown that the interception took place on a system that affects interstate commerce, and they have not shown that Mr. Weasel had a purpose at the point of the exploit of commercial advantage or private financial gain, and therefore we ask you to acquit. Thank you.
Thank you, Mr. Opsahl. And I've been told by the prosecution that there's no rebuttal, closing, or summation. So now we move to jury deliberations, which is the part where now you get to tell us what you think. How do you want to do it? You want to go with
Yeah, I
count
mean,
two
this
first?
is really a panel now. We transform from court. Court's over. Do you want to take a straw poll? Some years we do, some years we
Yeah,
don't.
let's do a straw poll.
All right, so why don't you put the counts up? Do you want to have a question before the straw poll? Or?
Okay.
What's the legal definition of commercial advantage? Does that necessarily include monetary component?
Somebody want to take that?
I mean, the question was, is there a legal definition of the phrase commercial advantage? And does it take, what was the last part? Monetary component. I mean, so answer one is there's no definition in the statute. So we have to look to see if cases have read it pretty broadly to be anything of value.
Yeah, anything of value. So like somebody gave you a car, they didn't give you any money, that would be something of value, and that would probably be private financial gain, actually, if someone gave you a car. For commercial advantage, like if you were working for a corporation and you did have shares in that corporation and they were being a much more successful competitor as a result and your shares gained in value, that might be either a commercial advantage or a private gain. So we tried to make this a hard question by having it be a nonprofit, by having it be an open source.
I mean, Hacker Court, we always talk about what's teachable moments. one thing that's clear is the jury, if you were sent back to the jury room, would probably ask that very question. You would come back, write a note to the judge. The judge would excuse you. The lawyers would fight like hell over it. And the judge may just come back and say, it means what it says, and I'm not going to tell you more. Or the judge might construct some very carefully crafted language that we've all kind of convinced the judge to agree on. So, okay, so knowing that, do you guys want to vote on count 2? So this is where the big fight, this was about the screen grab, which I think got a little complicated. But so if you vote in favor of the defendant, if you vote to acquit, which probably means you thought that this did not affect an interstate or foreign commerce system, please raise your hand now. You're voting to acquit on count 2. Bastards. Okay, now of course I have to ask the opposite because some of you just may not know. If you vote with me and my 2 young children to convict on count 2, raise your hand. All right, so unlike students in my law school, almost all of you voted. I'm very happy to see that. So of course I didn't get the unanimous verdict, but I might have gotten 12. That might be a record for Blackhat.
Is that how it works here?
You have to get at least 12?
Any 12.
Any 12. All right, count 3. Count 3, again, boils down to this last element, commercial advantage or, and it's only an or, private financial gain. So again, if you vote for the defendant to acquit, meaning you saw no motive of commercial advantage or private financial gain, neither one, please raise your hand. Ooh, even more, I think. Okay, and again, Max and Eleanor are their names. They're 5 years old. Very cute. If you vote with the prosecution for a conviction,
Objection, Your Honor.
please raise your hand. Yes, or fewer. Okay, so that's interesting.
Yeah.
I mean, under the unanimous rule, there's no conviction, but this shows that, you know, the government argument wasn't completely ridiculous this year. Okay, so now we'd love to just make this a panel. I mean, questions about any of this? Yeah.
Well, actually, before the question, I'll just start and say that taking off my defense hat and putting on my privacy advocate hat, I think that ROP reasoning that I was going through is a load of something I'm not going to call any result by a federal judge, but
shit.
The idea that someone could be monitoring your communications activity on your computer, but because it's doing it between components of the computer rather than between the computer and the internet, I think would absolutely eviscerate the wiretap statute's protections. And actually, this is something where EFF and the DOJ actually agree, because it's the DOJ that brought these cases for key logging. Which we think is very analogous to this screen capturing, but anyway, sure. Well, also for anyone who was wondering what Vaporospora was, that was a joke about Diaspora, which is an open source social network project that some NYU students were seeking funding for at the beginning of the summer. They were looking for 10 grand so they could work on it over the summer. We took a little jibe at them, calling it vaporware, but then again, they're coding it right now, so hopefully there will be something soon. But
they raised an incredible amount of money.
Yeah.
There was a lot of interest in the project, and it got.
They were only looking for 10 grand, but because Facebook was having a big privacy problem around the same time, and the New York Times did a story on them, they raised almost 200 grand. So if you were wondering.
All right, do I have questions?
Why don't you call people, yeah. Good question.